Catholic bishops advance medical directives. Those are directives that have been set forth that are consistent with the Catholic faith, and they recognize and support the Catholic ideals. So some of the key distinctions with the Catholic documents versus the traditional documents that are governed by state statutes is that the Catholic documents recommend retaining nutrition and hydration unless it becomes risky or hazardous to the individual. They also recognize the importance of last rites and the other sacramental considerations, and just generally incorporate various aspects of the faith into the documents. The more standard living will simply states that if two physicians, and I'm utilizing these based on Florida law, so I must say that as a caveat, that there are uniform probate and trust laws, but each state adopts their own variation of those. So when I talk about these definitions and qualifications for Medicaid, as I will in a few moments, please understand that that's based on Florida law because that's where I'm licensed to practice. I always recommend that you retain counsel in your state of residence because they will be able to advise you as to that state's statutes, because each state adopts their own variation of the statute, and so there can be differences from state to state. With a living will in Florida, if two physicians, your primary physician and a second consulting physician, says that you are terminal or in a persistent vegetative state or end-stage condition with no reasonable degree of medical probability that you will recover, then you do not want life-prolonging procedures employed. And that includes no tube feeding or intravenous fluids, if that's merely going to artificially prolong your life. So with these documents, as you can see, having a discussion with your family members is critical because they need to understand what your wishes are so that they can honor those wishes when the time comes if you cannot speak on your own behalf. And it's very important to have a conversation also about a do not resuscitate order. A lot of times clients will say that the living will is a DNR when in fact it is not. A do not resuscitate order isn't just that. It is a physician's order that is to be signed by both the physician and the patient, indicating that you do not want cardiopulmonary arrest to be, or CPR to be administered if you're in cardiopulmonary arrest. And it also, depending on the medical provider, if you're in a hospital setting, there's going to be questions outlined in that document about your preferences for intubation, being placed on a ventilator, both an internal ventilator and an external ventilator, and whether or not you want to have a tracheotomy if it becomes necessary to do that. And another big consideration with regard to healthcare decision-making is organ donation. So if you are an organ donor and you've got that memorialized on your license, that's great. Each state has their own organ donor registry. I've put here the Florida Organ Donor Registry. The great news about those registries is that all 50 states have access to the information contained on any one state's registry. So that means if you're traveling and you're in an accident and unfortunately you get killed, if you were in the registry, if you're in Colorado, even though you normally live in Florida, then that hospital in Colorado can look up, see what your wishes are, and try to make sure that they are honored. The Declaration of Preneed Guardian is the document where you have the ability to designate, in the event you are incapacitated in the future, you want this person or persons to be named as your guardian. The court will honor your wishes. So years from now, if there needs to be a guardianship established, and hopefully there won't be, because if you've got these advanced directives in place, there shouldn't need to be a guardianship established. But in the event there is one that gets established, this is your way of telling the court at that time, when you can't otherwise speak for yourself before the court, that this is what your wish is in terms of who's going to serve in that role. So when we're talking about long-term care, we need to first look at Medicare because, of course, that's the insurance that covers most individuals as they get older. That's one of the insurance coverages, of course. It's federal health insurance for those who are elderly or disabled. It is not needs-based. It is open to anyone who is 65 or older. And there are different parts, as I'm sure many of you are familiar with. Part A is eligible for retirees who are 65 or older, and that is afforded to you at no cost. Part B, you will be eligible for if you receive Part A coverage, and for this Part B coverage, there is a premium. Now, Part A covers inpatient care in the hospital setting. It covers home health care, hospice care, and limited skilled nursing care. And I'll explain in a little bit exactly how limited that is. Part B covers outpatient treatment, your physician visits, x-rays, medical equipment, ambulance services, and therapy, physical, occupational, speech therapy, respiratory therapy, all of the different types of therapies. Part C is what we call the Medicare Advantage plans. And they cover many of the same benefits that a Medigap policy would cover, such as extra days in the hospital after you've used up the number of days that Medicare covers. Part D is where we get our prescription drug coverage. So when we talk about limited skilled nursing care, what Medicare does is that for those individuals who need skilled level of care, so we're talking about rehabilitation in a skilled nursing facility, then they will cover the first 20 days at 100%. However, that is only if an individual is put into that setting after being in the hospital for 3 qualifying nights for something more than observational status. So typically what we will see is that someone who is older sustains a fall, they may break a hip, they go into the hospital for treatment, they cannot go home when their hospital stay is concluded, they are released to a rehabilitation center. If they go straight from the hospital to the rehab center, then Medicare will cover the rehab in the skilled nursing facility for up to 20 days at 100%. Starting at day 21, then they will cover 80% up to day 100. And that results for many in a copay of approximately, if you're on traditional Medicare, Parts A and B, for this calendar year, it's a copay of approximately $200 per day is what your patient responsibility would be. And just because it's up to 100 days doesn't mean that they have to cover you those entire 100 days. If they feel that you have plateaued with your level of care, then they can cut you off in terms of Medicare coverage. And at that point, you become private pay. The average number of days in terms of coverage is 30. If for those who are lucky enough to get Medicare to cover them through day 100, once they get to day 101, they're entirely on private pay. So that's where we start looking at what other public benefits may be available to help pay for that cost of care. The average cost of a skilled nursing facility in the United States can run anywhere from $8,000 to $10,000 per month. For many individuals, that is just simply cost prohibitive. Depending on your level of care needs, whether or not you're in a memory care unit, all of those affect the pricing arrangement. Certainly, assisted living facilities can also be quite costly. Those generally run in the range of $4,000 to $6,000 a month. And lots of individuals do not have what we call long-term care insurance. Long-term care insurance can also be cost prohibitive for many. The premiums are quite high. For many years, people were adverse to paying the premiums for long-term care insurance because they were a use it or lose it model. Like anything with insurance, right? You pay a lot in the way of premiums, and then God forbid someone passes away of a heart attack. They never had to go into a facility. They never got the benefit of that coverage, and all of the money spent on those premiums was lost. What the insurance companies have done in more recent years in an effort to encourage more people to seek out long-term care policies is they've developed what we call hybrid policies. And those policies are designed so that during your lifetime, if you need long-term care, they are available for your long-term care needs. However, if you don't fully utilize the long-term care benefits, then there will be a death benefit that can be payable, like a life insurance death benefit, to your family members or whoever you name as the beneficiaries on those policies. So that's something to consider when you're looking at long-term care costs, trying to decide how much coverage you need. One way to determine that is to do some research of what the average cost of a skilled nursing facility or an assisted living facility or memory care facility in your area costs each month. So if you don't have those kinds of coverages, or you have the coverage but you don't have enough to pay for your monthly care costs, then most often people will seek out benefits through their state's Medicaid programs. So Medicaid does vary state to state. There is a federal partnership, with the federal government, but these are state-run programs, and many states like Florida have opted to privatize them to a certain extent, where there are Medicaid managed care companies that have entered into contracts on behalf of the state with patients to manage their care, like Sunshine Health or Simply Healthcare, those types of organizations. So this type of coverage will pay for health and long-term care for low-income individuals, for those who are aged, blind, or disabled, and the state agency will determine your eligibility for those programs. Here in the state of Florida, it's the Florida Department of Children and Families that does that determination. Medicaid long-term care programs are home and community-based care service waiver programs. And again, these are going to vary state to state. So what I'm saying today is based on what Florida offers. Certainly, long-term care, elder law considerations, there's a lot to consider and can be very complex in trying to navigate this for you and your family. So I always recommend that you retain a counsel with an elder law attorney in your area to help assist you navigate those questions and concerns. So there's the nursing care program, nursing home care program, as well as the home and community-based care waiver programs. The waiver programs are designed to keep individuals in the community, either in the privacy of their own homes or in an assisted living facility setting. And those programs, at least here in Florida, are limited greatly by limited state budgets. As a result, we have a lengthy wait list here in Florida for those types of programs. We have over 37,000 people on a wait list for those types of programs. So it can be quite some time, even though they may be medically and financially eligible for those services, they just may not be able to obtain those services because of limited budget issues. I want to talk about a benefit at the federal level, because this is an important one, particularly when we are talking about memory care facilities and assisted living facilities, because again, at least here in Florida, it's very difficult to get Medicaid coverage for those types of level of care. So there's what we call a special monthly pension that is available for veterans and their qualifying surviving spouse or dependents. Today, we're going to talk about the veteran and the widow or widower of a veteran in terms of looking at their eligibility for these types of programs. So there's 3 different types of pension that is available. There's a low-income pension, a housebound pension, and an aid and attendance pension, all that are offered through the Department of Veterans Administration. Veterans aid and attendance benefits differ from Medicaid in that it is not a welfare benefit. It is a benefit that veterans have earned as a result of their service and their sacrifice for our country. Medicaid is the payer of last resort. So if you are a retired veteran or a veteran, as I'll describe, who would otherwise be eligible for VA benefits, you have to qualify or at least apply for those benefits to see if you qualify for them before you apply for Medicaid, because those come first, Medicaid comes last. Aid and attendance can provide that additional income to help you pay your cost of care either at home or in an assisted living facility. And given the lengthy wait list that we have here in Florida, it's a really critical program to avoid people from going into skilled nursing care to the extent that they may not be medically ready for a skilled level of care. So let's look at the basic eligibility in order to qualify for this type of VA pension options. You are either a veteran or a widow or widower of a veteran who the veteran must have served at least 1 day during an active wartime period. And I've outlined those here. They are set, these are dates that are set by the VA. So World War I, World War II, the Korean conflict, the Vietnam era. These are all examples. And then we've got more recently Afghanistan for our younger veterans. But you have to have served 90 days on active duty, okay? At least 1 day during a wartime period, 90 days on active duty, and received a discharge other than dishonorable. Something very important if you are a veteran or the spouse of a deceased veteran, please look for your DD-214 paperwork. That is the paperwork that shows the type of discharge that the veteran has from their service. If you served during World War II, it was called something different back then, but it serves the same purpose. And depending on when you served, there was a fire in the main institution where those discharge papers were held. And so for some individuals, their discharge papers were burned, the original ones. And so that's why it's very important to make sure that you have yours at home, locate those, because they may be difficult to obtain from the VA depending on when you were released from your service. Other components in terms of basic eligibility is that generally you need to have limited income and assets, and I'll explain in more detail what that means for the programs. You have to be 65 or older, or totally and permanently disabled, or a patient in a nursing home receiving a skilled level of care, or receiving Social Security disability insurance through the Social Security Administration, or receiving supplemental security income through the Social Security Administration. The distinction between those last 2 programs is that Social Security disability insurance is a benefit that you have earned based on your work history. If you work a requisite number of years and have paid into the system for Social Security purposes. Supplemental security income is a welfare benefit that's offered at the federal level through the Social Security Administration for those who meet certain income and asset requirements. You have to sign an application for your veterans benefits. And what the Department of Veterans Affairs has done is that they have established what we call VSO offices. These are veteran service offices that are located nationwide. And you can go online and locate the office that's in your particular county. They are staffed with retired military in most cases, and they are there to assist you in filing your applications and answering your questions about VA benefits and your potential coverage under those benefits. There are federal laws that prohibit individuals from charging you to help you file an application for your VA benefits. Now, if you get denied and there needs to be an appeal that's filed, then they are able to charge attorney's fees for that. But the initial application should be done at no cost to you. The first type of pension that's available is low-income pension. This is the VA's version of that supplemental security income that the Social Security Administration offers. And you have to meet all those basic eligibility requirements. And then you can't have income that exceeds what the VA calls the maximum allowed pension rate. So each year, these rates get adjusted due to inflation. And so the numbers that I've outlined here are those that are for the 2024 year. So these started in November. I'm sorry, they started in December and they go until November 30th. And basically, if you are a veteran and you are not married and you do not have a dependent child, if you make more than this amount per month, then you're not going to qualify to get this payment because that's the amount of the payment. And then if you're a veteran with a spouse or a child, then you are allowed to make $1,806.17 a month. And if you are a widower without a child, that's the amount that you would receive in terms of a maximum allowed pension rate. When you have the ability to qualify for housebound pension, that is a higher pension amount that is essentially added to that base pension I just spoke about when you are substantially confined to the immediate premises because of a permanent disability. And you will see these numbers are slightly higher than the low-income pension because they get a little bump for being housebound. And so these are the amounts per month that they have in terms of maximum allowed pension rate for an individual without any dependents, for those who are married or have otherwise one dependent, or a widow or widower. And the third type of pension is aid and attendance pension. So this is for individuals who are blind in a nursing home due to a mental or physical incapacity. They are bedridden due to a disability, or they require the aid of someone in order to perform activities of daily living. And so I've outlined some of those there, but do they need assistance with bathing and feeding and dressing themselves, transferring themselves from a seated to a standing position, cooking, or do they have incontinence issues? Can they live at home by themselves safely? Those considerations. With the aid and attendance pension, again, this involves the base pension with a bump. So this is the highest amount of the maximum allowed pension rate that is paid from month to month. So for veterans with no dependents, you see the amount there. With a dependent or a widower without dependents. You cannot get both housebound and aid and attendance pension. You get one or the other. So you start with your base pension, and if you qualify medically for these other types of pensions, then they will add additional amount each month as a result of those additional needs. So income limits. Yearly family income must be less than the amount set by Congress to qualify for the pension benefit. And those are the amounts that I talked about, those maximum allowed pension rates, those match the income limits. The pension benefit is the difference between the countable income and the annual pension limit set by Congress. So if you make less, if you're a veteran with no dependents and you make less than the $2,375 per month, then they're going to give you a benefit to make up for that difference. Now, a portion of your unreimbursed medical expenses may actually reduce your countable income each month. And what the VA does is they will take whatever your unreimbursed medical expenses are that exceed 5% of the maximum rate of pension. That can be deducted from your total combined income, which then increases the amount that the VA will pay to you. Where we see this come into play most often is for individuals who are paying privately, for instance, in an assisted living facility. If they're paying $6,000 a month, and we look at the bill and we see how much of that is room and board and how much of that is actually medical related, then they could wind up having a significant amount of deductions in the form of unreimbursed medical expenses, which then suddenly allows them to qualify for that VA pension. When we look at what counts as income, it pretty much includes all earnings as well, and that includes Social Security benefits, investment payments from your stocks and bonds and mutual funds, disability and retirement payments, any interest and dividend payments from annuities, and net income from farming or a business that you may be operating. Asset requirements. So from December, these are dates that are set by the VA from December 21st, 2023 to November 30th, 2024. The net worth limit to be eligible for veterans pension benefits is $155,356. So how do we determine what your net worth is? That calculation includes both your and your dependents' assets and income. So I've given you an example here. If you have $121,000 in assets and you've got $14,000 in annual income, then together your net worth would be $135,000. Since you have less than the $155,356, you would be eligible for the VA pension in any of those three forms: low income, housebound, or aid in attendance. When they look at assets, they're going to include the fair market value of all real property. So your land and your buildings, your homestead property, if you own commercial properties, and personal property that you own. And that includes cash and stocks and bonds, other investments, your tangible property like your furnishings, your vehicles, your boats, your boats, minus the amount of any mortgages that you have on those. Excluded assets that don't count are your primary residence, your car, and home appliances. So starting in October of 2018, the VA implemented a 3-year look-back period for asset transfers. So for those individuals who are trying to qualify for VA benefits by giving away their assets, the VA is now penalizing them. And the way they do that is during the application process. They will ask, have you given away assets for less than fair market value in the past 3 years? And if the answer is yes, then they're going to look at the value of what was gifted away. And they're going to divide that amount by what they have set to be the penalty period rate, which for this year is $2,727. And that will give you the length of time when a veteran is not eligible for pension benefits because they transferred assets for less than fair market value during that 3-year window. And that penalty period could be as long as 5 years, depending upon the value of what they gifted. So looking at Medicaid qualifications a little bit more closely, and again, for purposes of this presentation, I am using Florida Medicaid eligibility, but these will vary from state to state. Your basic eligibility requirements, then you have medical level of care requirements, and then you have financial requirements. So the basic eligibility requirements is that you have to be a U.S. citizen or a resident alien. Here in Florida, you have to be a Florida resident to qualify, and you can be 65 or older, blind or disabled. And of course, you have to have a social security number, and you have to go through the actual process of applying for benefits. Now, the medical level of care is very similar to what we talked about on the VA side. You require either an intermediate care or skilled nursing care or skilled rehabilitative care. You require assistance with activities of daily living. And so that means, again, walking, standing, dressing, bathing, feeding, toileting, or incontinence. Or you have a cognitive impairment that renders you having impaired decision making and limits your ability to live independently and safely in either in your home, in the community, or in a facility. The financial requirements are twofold. There's an income test and there's an asset test. The income test, again, each year is set by the government. So this year in Florida, you can have $2,829 per month in gross income. That's before any deductions are taken, and still be eligible for Florida Medicaid. Now, there are certain permissible deductions. And that number, by the way, is determined based on the SSI amount that's paid that same calendar year, which this year, supplemental security income amount is $943 paid by the Social Security Administration, and we multiply that by 3. So that's how we get our state Medicaid income limit. When you qualify, or if you apply for benefits, the income of the spouse, excuse me, is not considered. Their income can be unlimited. It is just the income of the individual who is ill, who's qualifying for benefits, that counts, at least here in the state of Florida. Now, spouse may be entitled to additional income if their personal income does not exceed a set amount determined by the government. And here in Florida, for this year, if a community spouse, the well spouse, does not have income of their own that does, can meet this amount of $3,853.50, we are able to reroute potentially some of the ill spouse's income over to the well spouse so that the ill spouse is paying less to the nursing home and maintaining that income for the sake of their spouse who's living at home or in the community. The asset test is that you can have $2,000 in countable assets, $3,000 in countable assets if both spouses are trying to qualify for nursing home coverage, and $154,190 is what the community spouse can have in the way of assets without negatively impacting the ill spouse. Now, keep in mind, at least here in Florida, we have a lot of assets that are not considered countable. Homestead property, if the individual expresses an intent to return to the house, even though that may not be medically possible, it's just a subjective intent and desire to return home, which who doesn't have that intent? And then retirement accounts are non-countable as long as they're paying out required minimum distributions or RMDs. Rental property is not countable as long as it's paying regular income. So prepaid burial plans are non-countable if they are irrevocable and cannot be cashed in. Life insurance policies that are term are non-countable. Those that are whole life are countable only to the extent of their cash value. So there's a lot of opportunities. We have burial expense accounts that are non-countable where you could set aside $2,500 in addition to your prepaid burial plan to help pay for the cost of a memorial service, flowers, food, and other things. So again, there's lots to consider, which makes it really vitally important for you to speak with an attorney in your area to learn the Medicaid qualifications for your particular state. So I know I've covered a lot of material this evening. Thank you for hanging in there with me. I am happy to address any questions that you may have to the best that I can.
Yes, I encourage everyone to use the chat option that we have down at the bottom on the bar. You can click the Q&A and submit any questions that you might have, and I encourage everyone to take advantage of this time that we have a professional who will help. But thank you so much, Vanessa. I wanted to take the time to say that we appreciate having your expertise here once again in our webinar series. We really appreciate the depth that you go into in these really important topics for our seniors today, especially.
Thank you so much.
We have a question here. It says, any particular advice for single seniors?
So for single seniors, sometimes it's actually easier to qualify for Medicaid when you're not married. It just depends on your state's eligibility requirements. So you definitely want to make sure that you have estate planning documents in place, because sometimes the state statutes will have presumptive rights when you're married, that your spouse can make certain medical decisions for you as your healthcare proxy. And when you're not married, there isn't that presumptive person necessarily. Maybe adult children, it may not be though. And for some of my clients, they don't want their adult kids to be making those decisions for them. They want a trusted friend or other family member. So definitely want to have your estate planning documents in place. And what I always tell folks in terms of the long-term care planning, the earlier you could start looking into long-term care planning, the better you are. For instance, with long-term care insurance, it's easier to get and qualify for those types of coverages before you become ill or have some kind of disabling condition. And certainly the premiums will be lower as well. And also some of the planning strategies for Medicaid eligibility and veterans benefits eligibility involve long-term planning strategies, like a Medicaid asset protection trust that we would want to implement more than 5 years because of the 5-year look back period when it comes to Medicaid eligibility in most states. More than 5 years before you think you're going to need to go into a skilled nursing facility. So it just kind of varies depending on where you live and what your particular needs are.
That was a great question. Thank you. All right, we'll give you another few moments to submit any last minute questions. And I will go ahead and just say, as we draw our session to our close, I want to extend a thank you to everyone who joined us today. It's been a privilege to share this time with you as we can further align our financial practices with our faith. I just want to invite you all to connect with us on our website and social media channels. Again, we do record our webinars and upload them onto our YouTube channel, where you can find the other topics that we've covered. Vanessa was able to open our first webinar series in January with estate planning, so I recommend that you take a look at our Compass Catholic Ministries YouTube channel for that. And we're hoping to see you in our following sessions. And thank you again, Vanessa. I believe that the last question we have here are there any tips for finding a financial advisor with expertise in seniors?
At least in my area, I'm finding more and more advisors who are adept with helping seniors navigate these types of issues. Here in Florida, we have the silver tsunami is what our local sheriff's office calls it. We have a lot of baby boomers who are needing assistance with these types of issues. So I, like anyone else, look to my friends, family members, my church for referrals. That's how people find me, because someone they know and trust referred them to me. So I would start there. Certainly, if you have a relationship with a CPA, a lot of CPAs have relationships with financial advisors. And then wherever your assets may be sitused, if you have accounts at Edward Jones or Wells Fargo or Fidelity, There are advisors, private wealth advisors and financial advisors that are affiliated with each of those institutions. So you may already have accounts at places and you're just not getting the full benefit of a possible advisory relationship.
Great, thank you.
Thank you. That was another great question. Thank you all. I
Yes.
really appreciate the opportunity to speak with you today. I hope that you found it informative. And thank you for taking the time to join us for the presentation.
Yes, well, thank you again, Ms. Vanessa. I hope that we are able to host you again in the near future. And I just want to let everyone know that we hope to see you in our next webinar next month. And I hope that you all have a wonderful evening and a blessed rest of your night. All right, God bless everyone. Thank you again.
Thank you. Bye-bye.